May I please, Your Worship?
Yes.
First, I would like to mention item number 8.
Item 8.
Worship, I've received a request from the opposite parties through the council that this matter will be listed for mediation at all.
Mediation.
Mediation.
Okay.
This is only for payment of the
Pending bills.
awarded amount.
Oh, okay.
This is a case where the respondent number 1 was allocated.
Okay. So it's they are also willing. The other side.
No, I was approached by the respondent through the council
Okay.
that they wish to go for mediation.
mediation.
So I'll take the instruction from the appellant. So the matter may be posted for mediation.
Or you get the instruction first whether they would like to refer it for mediation.
Okay.
Next week. We'll list it next week.
Okay.
Third learned additional Advocate General for the appellants, Mr. Im Stop. It is submitted that the respondents have contacted him and have stated that they would like the case to be referred for mediation. So the learned additional AG therefore prays for some time to receive instructions from the appellants as to whether they would like the case to be referred for mediation. So list after a week.
May I please?
Yes, yes.
My Lord, I beg permission, item number 17.
17.
Yes. My Lord, this matter will come up after 3 weeks, my Lord. In the previous question, my Lord, as per the instructions, I have submitted a letter, which one is sent to me, but that one is not on the record, so that letter I have placed before that there's an overcall.
What letter?
That regarding to defend by the state respondent and the initiative.
Is this regarding compensation?
Yes, my Lord.
Okay. How much time? 3 weeks.
3 weeks time now, my Lord.
But I think it's a very old case, not 2022.
Yes, my Lord.
3 weeks.
And for respondents,
Okay.
actually,
Yes.
the instruction is that Ministry of Road and Transport, this case will be defended by the state respondent and by the initiative. That's what they are writing letters to the initiative as well as the state.
No, who is liable actually? Who is liable? If
One
at
of
all,
the state respondents.
they are also saying they are not liable.
We are only a supervisory.
The supervisory. You sort it out. Learned Council.
Lordship, a last chance may be given because this is to round into matters.
So, my own
That's
capacity, my Lord, by my own capacity, I cannot do anything, my Lord, without the instruction, my Lord.
Written instructions you
yes.
want. Learned Council for the petitioner, Mr. Chengme Kungyak is present. Stop. Learned CGC, Mr. ZN Muli submits that he would like to get written instructions from the respondent number
2, my Lord.
from the respondent number 2 regarding the agency which is liable to pay the compensation, isn't it? So, learned additional AG, Mr. LT Sanctum is present, and Mr. Moa Jamir is present for the respondent number 7, and Mr. Sen is such for respondent number 6. List after 3 weeks as prayed for as a last chance, last opportunity. Yes.
Much obliged.
My Lord.
Yes.
Please, Your Lordship. May I be pleased to mention item number 6 and 7, Your Lordship. Lordship, if this matter can come up after 4 weeks, Your Lordship.
Lordship, this is regarding non-payment of bills, Lordship. A specific direction has been given to clear the bill.
Yes,
Lordship, the amount is
pending bills.
Lordship, the amount is too big.
Yes, Your Lordship.
8 lakhs
Both combined.
combined. Yes.
Your Lordship,
What happened?
Your Lordship,
You pay them.
yes, Your Lordship, they are.
It is not disputed, isn't it?
No.
No, but then we need time, Your Lordship, because budget season is going on, and so we need time, Your Lordship. That's why. Otherwise, we are.
Preparing to pay.
So So 4 weeks, Your Lordship.
Learned Counsel.
Lordship,
for
that
the-
assurance may be given, Lordship.
Your Lordship, on the next date, I'll bring the written instruction because as of now, to Your Lord, they're verbally informed on the phone. So let me submit the written instruction on the next date.
Learned Counsel for the respondents, all the respondents.
I'm for number 2 and 3, Your Lordship.
Respondent number 2 and 3, Ms. Livika and Mr. N. Angami for the respondent number 1, praise for 3 weeks. 3 weeks.
4 weeks, Your
For
Lordship.
Lordship,
weeks,
since they are going to get written instruction, so
No,
3 weeks.
if you take 4 weeks, you pay them in the meantime.
No, Your Lordship, as you are well aware, Your Lordship, of the record, Your Lordship, but it's under like they have this process in the budget also, Your Lordship. So the financial year. So we will be requiring the March and by April, I think Your Lordship it will be paid, Your Lordship. However, Your Lordship, time
Okay,
will-
okay.
that is
4
off the
week-
record.
4
of
weeks
the
time,
record.
4 weeks time.
4 weeks,
to
then they'll
receive
come in
further
March.
instruction, and it is stated that that the dues which are pending to the petitioner is being considered.
Yes, yes,
Is
it
being
will be,
considered.
the written instruction will,
It's
let's
being
it on the
considered.
next date.
Okay, we'll just say that it's being considered. Stop. General Counsel for the petitioner, Mr. N. Mosi is present and has no objections. List after 4 weeks.
Oblige, Lord.
Your Lordship, I also beg to mention item 14 and 15. Item 14, 15 and 16. Your Lordship, a similar matter is pending, Your Lordship, before the division bench, Your Lordship. So if this matter can come up after 4 weeks only, Your Lordship.
Learned Counsel for the petitioner, Ms. Such and such is present. Stop. Learned Government Advocate, Ms. Livika submits that similar matters are pending adjudication before the division bench. Can you give any number, WA number?
Your Lordship, on the last day, I think it is being going on because 2 litigation went, Your Lordship. One
No,
is
no,
like,
number. Can you
numbers
give
are already
the?
given before, Your Lordship. Long time back, Your Lordship.
Okay, can you just give me the records? Item 14, 15 hearing. You just check the report and fill it, okay? What did I say last time? Similar matters are pending before the division bench in WA number such and such. Okay,
Oh, Your Lordship, I think it's written 234 2025, Your Lordship. The recent one, I think I may not have given, Your Lordship. The previous one, Your Lordship, the government went. So again, they have gone for SLP, Your Lordship. Another is pending before the division bench.
you just make sure and then submit the
Okay.
number later. WA such and such. Huh? Accordingly, list the matter after 3 weeks.
4 weeks, make
After
it
4
4
weeks. Yes. Yes.
May I please, Your Lordship? Lordship, I beg to mention item number 33 and 34, Your Lordship. Supplementary.
Supplementary.
Yes, Your Lordship. Lordship,
This is for mediation, I think.
yes, Your Lordship. My client is not willing for mediation.
33 and 34, no?
Yes, Your Lordship. So kindly list this matter on that 9 March.
Okay.
Lordship, we
Learned
have
Counsel.
yet to file our counter affidavit. 2
Okay,
weeks time may be granted.
you file within the time they are praying for 9th March. Learned Counsel for the petition, appellant, petitioner, Ms. Tayekrolo submits that the petitioner is not willing to refer the case for mediation. Stop. Mr. I. Jamir appears for the respondent, complainant, and prays for 3 weeks' time to file his affidavit in opposition. Stop. Accordingly, list the matter after 3 weeks. We'll just say 3 weeks.
Lordship, there's interim in both of the
Interim
item
order
number
passed
33 and
earlier
34.
shall continue till the next date. Yes, in both.
Yes, Your Lordship. Yes.
May I please, Your Lordship? I beg to mention item number 24. Your Lordship, here the petitioners have agreed for mediation.
Ready?
Yes,
Willing?
yes, you are.
What about you?
Your Lordship, in this regard, I need to take instruction from my senior. Can you allow me some time?
Learned Counsel for the petitioner, Ms. Such and such submits that the petitioner is ready for the matter to be referred for mediation. However, Ms. Such and such appearing for respondent number 2/complainant prays for some time to receive instructions from the respondent. Stop. Respondent as to whether he is willing to refer the matter for mediation. Stop. Accordingly, list the matter. 1 week, okay? List the matter after 1
Your
week.
Lordship,
in
there is an
order
interim
to-
order.
In order to enable the respondent number 2, the counsel for respondent number 2 to receive instructions. Stop. The list after 1 week, the interim order passed earlier shall continue till the next date. Yes. Tiba PP. Yes.
Item number 30 for mediation.
13.
30.
30.
30.
Oh, yes.
With due respect,
MSc.
yes. We have already been, I don't think there'll be a meeting point because we think that we have been awarded the amount which much lesser than what we are due probably. So unless they agree to pay what has been awarded.
It's up to them.
Lordship, if we will not be putting up the case for mediation, Lordship.
Okay. Learned Counsel, heard Learned Counsel for the appellant, Ms. Kim Penyu, and also Mr. Imti Longjam for the claimant respondents. Both the parties are not willing to refer the case for mediation. Accordingly, list the matter after. At what stage? Is it for hearing?
No, even delay has not been confirmed.
Oh, okay. List the matter when? After a week?
No, after 3 weeks, Your Lordship.
After 3 weeks. Yes.
Lordship, I beg to mention item number 35, Your Lordship. 35.
Yes. 35.
Yes, we have agreed for mediation, Your Lordship.
Okay. Learned Counsel, Ms. Kim Penny, appearing for the appellant, submits that the appellant is ready to refer the case for mediation. So accordingly, the matter is referred for mediation under the special mediation drive. So the parties shall appear before the registrar, Gauhati High Court, Kohima bench on 23rd February 2026, and thereafter fix a date for the mediation process. Stop. List after the completion of the mediation process. Yes.
Lordship, I beg to mention item number 21 too. Here we have agreed for mediation.
Okay. Here also, you have also agreed. Okay. Here also same order, Ms. Kim Penyu, and then for the respondent, you just note her name, Ms. Such, and as well as learned government advocate, Ms. Pichana Kitan. Who? Oh, Mr. N. Longkaman. So he also has to appear. Okay. And then same 23rd, same day, 23rd February. Okay. And then same order. Like
The state is still to receive instruction whether they will go for mediation or not. So sometime we cry the motion.
What is the matter about item 21? What is the issue?
It's for regularization also.
Regularization?
No, Your Lordship, land ownership.
Land ownership. Yes. And you are for the private respondent?
Yes, Your Lordship.
Then government also, if you are admitting that he is a landowner, then okay. Don't write that referring for mediation, okay? Just say learned government advocate Ms. Pichano Kitan submits that she would like to get instructions from the respondents regarding the willingness for the matter to be referred for mediation. Accordingly, this is the matter after 1 week. After 1 week. Yes.
Lordship also like to mention item 19, Lordship.
19.
Here I also yet to receive instruction, Lordship. So if sometime we granted, Lordship.
Okay. Here also, same thing as to whether the matter will be referred for mediation.
Lordship, item 20 on behalf of M. Senior player, Lordship.
Here also, same prayer.
Lordship.
Okay, same.
25 as well, Lordship.
25 also, yes.
Lordship, item 32 as well, Lordship.
32 also, same order.
Lordship, in item number 32, the petitioners have decided not to go for mediation.
Not to go.
Yes.
Okay. Then in 32, you say that learned counsel for the petitioner, Ms. Menuseno, has submitted that the petitioner is not ready to refer the case for mediation. So accordingly, counter has been filed.
Yes, sir.
Government. Accordingly, list the matter after 3 weeks. Yes.
Mr. Lordship. Lordship, I beg to mention item number 26, 27, and 29, Your Lordship. All the parties are represented by the same counsel, Your Lordship.
26,
26, 27, and 29, Your Lordship.
29.
Your Lordship, for mediation, we are yet to receive instructions, so if another 1 week time may be allowed to me.
Okay. Learned counsel for the petitioner, Mr. Muad Jamir is present. So learned counsel, Mr. Chen Yip Hong, appearing for the respondent.
1 to 4.
1 to 4 submits that he would like to receive instructions from the respondent as to whether the matter would, can be referred for mediation. So accordingly list the matter after 1 week. 1 week, in order to enable the respondent to, counsel for the respondent to get further instructions. What about petitioner, willing?
Yes, Lordship.
Okay, okay. Yes.
Obliged.
Obliged, Lordship.
May I please, Lordship?
Yes.
Lordship, item number 22 and 23. My clients, they are not willing for mediation, Lordship.
22 and 23.
Lordship.
Okay, item 22. Learned counsel for the appellant is present. Learned counsel, Mr. Sarif Ahmed, appearing for the respondents that the respondents are not willing to refer the case for mediation. So accordingly list the matter after 2 weeks. Okay. Then item
3 weeks, Lord.
after 3 weeks.
3 weeks, 3 weeks, Lordship.
3 weeks. Then item 23.
Yes, we are not willing for mediation.
Appellant. Item 23, who appears for the appellant? Learned counsel for the appellant, Mr. Pedovero is present. Learned counsel, Mr. Sharif Ahmed, appearing for the respondents, submits that the respondents are not ready to refer the case for mediation.
Mediation.
Accordingly, list the matter after 3 weeks. 3 weeks?
Lordship. Deeply obliged.
May I please, Your Lordship? I beg to mention item 19. Your Lordship, we are waiting for mediation.
Item 19. Okay, okay. It's already, someone has already adjourned it, I think. Item 19, isn't it? Anyway, item 19, order passed. Oh, not in 19, nah. Similar order is 21.
Your Ladyship might have mistaken actually. 19 is actually not 19.
Okay, delete that other one then. Item 19, nah. WPC 1, WPC 70.
70.
Yes, Your Lordship.
Yes, can it be referred?
Yes, Your Ladyship. You are open to it.
Who's appearing for the government, but? Item 19. What is the issue?
It's
No. What is the issue? What is the subject? This one.
it's
Your
they are
Lordship.
challenging my appointment.
Land ownership.
Yes, Your Lordship.
Then in that case, government also should be willing. If the government is not willing, then Mr. N. Angami, just appear in this case also and seek instructions as to whether it can be sent for mediation. Okay, 19.
Lordship.
Learned counsel for the petitioner, Ms. Such and such present. Learned counsel for respondent number 4, Mr. James Newma is also present. It is submitted that the petitioner and the respondent number 4 are willing to refer the case for mediation. However, the learned government advocate, Mr. N. Nangami, shall obtain instructions as to whether the...
Lordship, in fact, this matter is handled by Bichano. I think she was the one who was adjourning the matter, in fact. But I will inform her.
Anyway, you inform her
Yes, I will inform her.
as to whether the respondent government is ready to refer the case for mediation, at least after 1 week.
May it please Your Lordship, I beg to mention item number 20, Your Lordship. The matter is about land ownership.
Item
Your Lordship.
20.
Yes, item number 20. We're ready for mediation, Your Lordship.
No, this one also is already mentioned, if I'm not mistaken. Isn't it 20 also? No. Okay. Who's appearing for the government? Item 20.
M. Lokumar, Your Lordship.
Here also, same thing. They are ready for mediation, but government has to get the instructions, okay?
Yes, ma'am.
Learned
All informed
counsel
them.
for the petitioner, Ms. Kim Penny is present. Stop. Learned senior government advocate, Mr. N. Nangami, shall receive instructions as to whether the state respondent is ready to refer the case for mediation. Stop. List after 1 week.
Lordship, there's an interim.
The interim order passed earlier shall continue till the next date. Yes.
Lordship, if I may, item back to mention item number 36, Your Lordship.
Yes.
In this matter, we will not be going for mediation. We have not agreed for mediation.
36, learned counsel for the appellant, Ms. Kim Penny, submits that the appellant is not ready to refer the case for mediation. Accordingly, list the matter after 2 weeks.
3 weeks,
After
Your
3
Lordship.
weeks, yes.
Your Lordship, similar submission for item number 28. Here we have
Not
not
ready.
agreed. Yes, for mediation.
28.
Yes.
Okay, item 28 also, same order. Yes. So list after 3 weeks.
Mediation.
They are not ready. Not ready, isn't it? So list after 3 weeks. Yes.
Please, Your Lordship. Your Lordship, I beg to mention item number 31. Here, Your Lordship, I'm yet to receive instruction from the department as to whether they wish to go for mediation. So can they grant me another week, Your Lordship?
Petitioner? What about you?
Lordship, the petitions are ready, Lordship. The petition.
General counsel for the petitioner, Ms. Meka H.I.A. submits that the petitioner is ready for mediation in this matter. So, however, learned government advocate, Ms. A.I.M.E. submits that she would like to get instructions from the respondents as to whether they would like the matter to be referred for mediation. So, accordingly, list 1 week. List after a week. Yes.
Please, Lordship.
Yes.
Lordship, I'd like to mention item 3 and 4.
3 and
Lordship,
4.
The counsel for the appellant is indisposed and none of his juniors are available. So if this matter can be listed after 3 weeks, Lordship.
Admission item 3 and 4.
Yes, Lordship.
Who's indisposed?
The counsel for the appellant.
Counsel for the appellant. No, 4 is a civil revision. I think you're mentioning on 3. Learned counsel, Ms. Such and Such, appearing on the behalf of Mr. V. Devnath for the appellant, submits that the leading counsel is indisposed and accordingly prays for listing the matter when?
Lordship, and for respondent 1 and 2. 3 weeks.
No, you're mentioning on behalf of appellant or the respondent?
Lordship, I'm for respondent 1 and 2. I've received instructions from the counsel for the appellant.
How can you mention for the appellant when you are appearing for the respondent? You pray on your own behalf. Learned counsel, don't delete that. Learned counsel such and such appearing for the respondent prays for how much time?
3 weeks.
3 weeks time to file reply, to file an objection.
No, Lordship, we've already filed.
You've already filed.
Yes,
Okay. Just say list after 3 weeks as the leading counsel is indisposed. Okay.
Yes, Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 38, Mark. 38.
Mediation.
Mediation, my Lord. Lordship, here we have taken instructions, but the insurance company are not agreeable for the mediation.
They are not ready.
No.
Learned counsel, Mr. Medo Vero, appearing for the appellant, submits that the appellants are not ready to refer the case for mediation. So accordingly, list the matter after 3 weeks.
Okay. Much obliged, Your Lordship.
For motion, item number 39. May I please your Lordship? This is an appeal against judgment and order dated 17/11/2025, passed by MECT Dimapur. I have a small ground only.
Let's see.
They've come before the learned MECT under section 166 and 144 instead of 163A. As per the police report, there's no negligence on the part of there's no rash and negligent driving on the part of the driver. So that's the only ground.
Okay. Fail to consider the submission. What did you say? The police report stated that it was not, there was no rash negligent
Rash and
driving.
negligent driving.
The present appeal under section 173 of the NV Act has been filed assailing the impugned judgment and order dated 17/11/2025 passed by the learned MECT Dimapur in MEC case number 99 of 2015 by which the appellant has been directed to pay a compensation amount of rupees 9,15,600 with interest at 7.5% per annum from the date of filing of the claim petition. So, heard learned counsel, Ms. Majumla for the appellant, who submits that the main ground on which the present appeal is filed is that the tribunal failed to take into consideration the police report, which clearly stated that the accident was purely clearly states that there was no rash and negligent driving involved in the accident. Stop. Better. Admit the appeal. Call for the records from the learned MECT Dimapur. The appellant shall take steps for service on the respondents number
1, 2,
3 by Inland Speed Post document as well as usual process within 3 working days. List after 4 weeks.
Your Lordship, IE is for stay. So, IE 19 of 2.
Okay, subject to deposit 50%. Third learned counsel for the appellant, for the applicant. So this present IA has been filed praying for stay of the impugned judgment and order dated 17/11/2025 passed by the learned MECT Dimapur Nagaland and MEC case 99 of 2015. Stop. Para. Learned counsel for the applicant / appellant Ms. Majumla, who submits that the applicant has filed an appeal against the said impugned judgment and order dated 17/11/2025, which has already been admitted. So, accordingly, the learned counsel submits that the appellant has taken good grounds for appeal, which is likely to succeed, and therefore it submits that if the impugned judgment is not stayed during the pendency of the appeal, grave injustice will be caused to the appellant hearing, and therefore prays that the impugned judgment and order may be stayed pending disposal of the appeal. Stop. Para. This court has considered the submissions of the learned counsel and perused the pleadings. So, the appeal against the impugned judgment and award dated 17/11/2025 has been admitted by this court. Stop. Accordingly, the impugned judgment and order dated 17/11/2025 in MEC case 99 of 2015 is state pending disposal of the appeal petition number 2 of 2026, subject to the condition, on the condition that the appellant shall deposit 50% of the award before the registry of this court within 4 weeks from today.
Item number 40.
May it please your ladyship.
Yes.
This contempt is filed for non-compliance of this honorable court judgment and order dated 14/5/2025. Lordship, the operative portion is at page 27. By this order, the dismissal order of the petitioner and the order of the court of inquiry and the letter by which the petitioner was denied disability pension was set aside, and at para 30, a fresh court of inquiry was directed to be convened by the respondents.
They have not convened.
No, Lord. Till date, no. And thereafter, we sent notice to the respondents as well on 27/5/2025. However, the service to the commandant 32 Assam Rifles was refused and it was returned to sender. However, that may not be an issue at this point. And just...
and what is this division bench judgment?
Yes, Lordship, here they filed a writ appeal against this order. However, since there was a delay of 246 days and without reasonable explanation, it was dismissed. The application for condemnation itself was dismissed.
Okay. Learned counsel for the petitioner, Ms. Opang Lalongcha. Stop. This is an application for praying for initiating of contempt proceedings under section 11 and 12 of the Contempt of Courts Act, read with the Contempt of Courts Gauhati High Court Rules 1977 and Article 215 of the Constitution of India, alleging willful disobedience of this court's order, judgment and order, dated 14/5/2025, passed in WPC 71 of 2024 and WPC 314 of 2023. Stop. Learned counsel for the petitioner submits that by the order dated 14/5/2025, this court had directed the respondent authorities to convene another fresh court of inquiry, giving due opportunity to the petitioner to participate in the inquiry and pass necessary orders after giving him an opportunity of being heard. Stop. It is submitted that the petitioner had taken steps to transmit a copy of the court's order to the respondents. Where is that letter?
Page 28. The date is at page
letter dated, letter dated 27/5/2025. The respondents had also filed a writ appeal against the judgment dated 14/5/2025. However, the same was filed with a delay of 246 days. Stop. The division bench, by order dated 28/1/2026, in IA Civil 7/2026 had dismissed the IA, and the delay was not condoned. So it is therefore submitted that the judgment and order dated 14/5/2025 needs to be complied with by the respondents. So hence the present application. Para. Issue notice returnable within 4 weeks. So the learned counsel for the petitioner shall take steps for notice on the respondents 1 to 4 by speed post document as well as usual process within 3 working days. List after 4 weeks.
Item number 41 and 42.
May I please, Your Lordship?
Yes.
Lordship, this IA is filed praying for impleadment of the new incumbents, Sri Santiago Imchen IS, Chief Secretary as respondent number 6, Sri Kesonyo Yome IS, Finance Commissioner as respondent number 7, Sri Gregory Tejavili IS, Commissioner Nagaland as respondent number 8, and Sri Temsuwati Longkumar NCS, Deputy Commissioner Kefiri as respondent number 7 in COP 18 of 24. Lordship, on the last occasion, by
all
order...
of them transferred out?
Lordship, yes. Lordship, on the last occasion, by order dated 5/2/2026, this Honorable Court is directed to implead the new incumbents in place of respondent number 4 and 5. Lordship, however, during the pendency of the contempt, even respondent number 1 and 2 are no longer holding the said post anymore. The new incumbents has taken over the charge. So the applicant is seeking the liberty of this Honorable Court to allow the impleadment of the new incumbents in place of respondent number 1 and 2 as well.
The present application has been filed by the applicant praying for impleadment of the new incumbents, Sri Sintiangar Imchen IS, Sri Kasino Yome, you just see from the cost title, okay? IS, Sri Gregory Tejawile IS, and Sri Temsuwati Longkumar NCS as respondent number 6, 7, 8, and 9 in the COP civil number 18 of 2024. Stop. The heard learned counsel for the petitioner, Ms. Such and Such, who submits that during the pendency of COP civils 18 of 2024, the respondents number 1 and 2, 1, 2, 3 and 4, isn't it?
Yes, 1, 2, 3,
1, 2, 3 and 4 have all been transferred out from the concerned department or has retired from service. Stop. And accordingly, it has become necessary to implead the new incumbents. Stop. It is therefore prayed that the above mentioned new incumbents may be allowed to be impleted as respondents number 6, 7, 8, and 9 in the COP Civil 18 of 2024. Stop. Having considered the prayer of the learned counsel for the petitioner and having regard to the fact that the earlier respondents are no longer in the concerned department, the application is allowed. Stop. The petitioner shall take steps to file an amended cost title within 1 week from today, and thereafter take steps for service upon the newly impleted respondents. Disposed.
Item number 43 and 44.
Please, Your Lordship. Your Lordship, I on behalf of the petitioner, Your Lordship, this IA has been filed in compliance to the Honorable Court order dated 10/2 of 2026. Your Lordship, that a contempt petition COP 11 of 2025 was filed on 25/2025. That in the same contempt petition, Srimati M. Mamnu Konyak has been reflected as Additional Director HOD Department of Rural Development in the cost title. Your Lordship, it is humbly submitted before this honorable court to kindly allow the petitioner to amend the cost title in the contempt petition COP 11 of 2025 by amending the designations of respondent number 3 as Srimati M. Mangno Konyak, Director Department of Rural Development, and respondent number 4 as Sri Ibo Chang, Block Development Officer, RD Block Noksang Tingsang, Nagaland.
Tribunal Counsel for the applicant petitioner, Ms. Sajan Sir. The present application has been filed, praying for allowing the applicant to file an amended cost title in the pending contempt petition civil number 11 of 2025. It is submitted by the Learned Counsel for the applicant that by order dated 10/2/2026, this court had directed the petitioner to file an amended cost title by altering the designation of respondent number 3 as director and not additional director, Department of Rural Development, and to implead the respondent number 4 by name and not by designation. Accordingly, the present application has been filed. Learned Counsel for the petitioner therefore prays that they may be allowed to, but the petitioner may be allowed to amend the cost title in the contempt petition COP Civil 11 of 2025 by amending the designation of respondent number 3 as Director, Department of Rural Development, and respondent number 4 as Sri Ibo Chang, EBOU Chang, Block Development Officer, RD Block Noksen Tuensang, Nagaland. Court has considered the prayer of the petition applicant, and the application is hereby allowed. The applicant shall file the amended cost title within a period of 1 week from today, and thereafter take steps for service on the respondents number 3 and 4. Respondents number 3 and 4. Yes.
For admission, item number 1.
My please, Your Lordship. We are here to file our affidavit in reply. So I pray for 2 more weeks to file our affidavit in reply.
Affidavit in reply to the counter of all the respondents?
Yes.
No, you should do the additional affidavit filed by the respondent number 2.
Learned Counsel for the petitioner, Mr. Sergeant Such is present. Learned Counsel submits that they would like to file a reply to the additional affidavit filed by the respondent number 2, and accordingly prays for how much time?
2 weeks.
Accordingly prays for 2 weeks time. So prayer is allowed. Learned Counsel, Mr. N. Longkamer appears for respondent number 2, and Mr. Im Tim Song for respondent number 4. So list after 2 weeks.
Item number 2.
My please, my lord. This honorable court order dated in 10/8/2023 and WBC 3 out of 2022 has been fully complied with. So I pray that the contempt petition may be closed.
Complied with?
Yes.
Okay. Judgment is page
17. My lord, 10. Next year one, 10.
Page 10. Okay. Learned Counsel for the petitioner, Mr. Sipamwati Wali, has submitted that the direction of this court in WPC, in order dated 10/8/2023, passed in WPC 338 of 2022, has been fully complied with by the respondents, and therefore prays that the matter may be closed. Stop. Learned Counsel, Mr. Moangchen appears for respondent number.
Your Ladyship, I am for respondent number 5, 6, and 7.
5, 6, and 7, and Mr. N. Nangami.
Your Ladyship, respondent number 3 is my colleague Mosam Salongomba.
Mr. Muslim Salam Kumar for respondent
And
number 3.
Your Ladyship, respondent number 4 and 2 is Mr. Ejimo.
Vizimo.
Oh, Vizimo.
Vizimo for respondent number
4 and 2.
4 and 2, and Mr. N. Angami for respondent number 1. Stop. Para. Accordingly, as submitted by the learned, as briefed by the learned counsel for the petitioner, the matter is closed and disposed of.
Item number 4.
May it please your Lordship.
Civil revision.
Civil revision.
Yes.
Lordship, by this civil revision, I'm challenging the impugned judgment and order of Deputy Commissioner Kohima on the ground that the second appeal, which I have moved under Rule 29(1) of Rules for Administration of Justice and Police in Nagaland, the matter has been disposed of without going into the merits. Solely on a technical ground, my matter has been decided, and therefore, assailing the judgment in order of the Deputy Commissioner, I'm here before this Honourable Court. Lordship,
yes.
Allow me to give a brief overview of the factual background of the case. The present case, it relates to a land dispute, and where ownership and title, this are involved, and therefore adjudication is necessary in the present case. Now, in 2007, the petitioners, 2 of them, they purchased a land at Duck Lane, Kohima, which falls under Kohima village jurisdiction, ancestral jurisdiction, Lordship. Lordship will find
there are 2 petitioners.
2 petitioners, Lordship, and 1 respondent. Lordship will find the sale deed in Annexure 2, page 32 of my petition. The type copy is in page 33, Lordship.
Yes.
So, Lordship, on the basis of the sale deed, a land measuring 120 feet into 68 feet were purchased by the petitioners from one Viketulia Solo. And Lordship, this is important. The petitioners were aware that from the beginning that the land, it is a joint property of a family belonging to Solo clan. And when Viketulia Solo, the seller, sold this to the petitioners, he has informed the petitioners that the elders were consulted. And in the sale deed also, Lordship will find that there are 2 elders who are signatory to the sale deed, who bore witness to the sale deed, Lordship. Now, after purchasing this land, Lordship, one person, namely Tinhovilla.
This is not a proper sale deed, actually.
Lordship, I admit that this is not a proper sale deed. However, the agreement was executed in this form, Lordship. And after taking possession, one person from the same clan, from the same sub-clan, Lordship, of Solo, namely Tinhovilla, he approached the petitioners and offered them to buy the adjacent land, which also is a part of that joint property. However, the petitioners, since they don't have the resources to purchase that adjacent land, they declined in purchasing that land. And at this juncture, this person, Tignoville, he also asked the petitioners about the defined boundaries, the boundary where they have purchased, and to show him the boundaries. So they have showed him accordingly. Later on, to the surprise of the petitioner's lordship, this same person, lordship, before that, there is another event. After the defined boundaries were shown, he asked them to purchase. They did not purchase. He got agitated, and then he approached the respondent. And the respondent has purchased the adjacent land. Now, to the surprise of the petitioners, it was learned that not only the adjacent land, but even the land which was already sold to the petitioners were sold to the same person again, to the respondent. And aggrieved by this, the petitioners, they have raised objections time and again. However, forcefully, the respondent has started carrying out constructional activities in the form of constructing a pillar post in that disputed land, lordship. And
when was it sold to the respondent?
Lordship will find this in Annexure 4. This was sold in the same year. To the petitioners, it was sold in February. To the respondent, it was sold in the month of September, lordship. Lordship will find this in page number 36, Annexure 2, the translation of, Annexure 4. Lordship, the agreement reads, today, 2007, we give the land situated at Fecheke, Duck Lane to Mr. N. Lao Solo at rupees 80,000 only, and the boundaries were indicated in the form of south, east, west, and north, but however, there was no land measuring. So I do not know, by simply basing on this document, I cannot tell whether my land has been included in this sale deed or not. However, that is the claim of the respondent, that my land has also been lawfully purchased, purportedly by the respondent. Now, since lordship, the respondent has forcefully carrying out activities, complaints were made to the village council, and village council has issued one land certificate in my favor, Kohima Village Council, which is in Annexure 3, lordship. Page 34, lordship.
Yes.
Now in this also, lordship, the chairman of the TKL also is a signatory to this document. There is another elder from the Solo clan who was also a signatory to this document. May I read?
This is in 2018.
2018.
Yes, then what happened?
And lordship will also find that in this document, the Kohima village chairman also appended his signature as one of the signatory in this land document, land certification document. Thereafter,
North, south, east, west. Okay, then.
Since the encroachment continues, the petitioners, they approached the GB's court, Kohima village. And Lordship will find the GB's court's decision in Annexure 5. The translated copy is in page 40, Lordship.
Who approached? The petitioner approached?
The petitioners. It's a very short judgment. May I read, Lordship? Kevisen Nazachu and Party versus N. Lao Solo. Upon hearing both the parties and on verifying the land, Kevisen Nazachu and Party brought the land at Fecheke Duck Lane below the road, and Mr. Vikatulia Solo, but lineage of the three grandfathers had sold the land to N. Lao. Therefore, Kohima village GB's court gives the following order. Number 1, Vikatulia Solo and the descendants of his grandfather will give one piece of land to Kevisena and Party, either as per earlier agreement or more than that. Number 2, if the first order cannot be abide by the parties, they shall pay interest and principal for 12 years amounting to rupees 4,75,600 to Kevisena Zachu and Party. If any party cannot abide by this order, they should adjudicate before any other court within a period of 1 month. And there were 9 GBs who adjudicated this matter. And Lordship will find that this is very interesting. The GBs in their findings, they are acknowledging that I was the first one who had purchased this property. I have lawfully purchased this property. However, instead of pronouncing that the property should belong to me, an alternate plot, it is their proposal that alternate plot should be given to me, either that or compensation should be paid to me. And because of which I was aggrieved and I approached the Deputy Commissioner on appeal after this, Lordship. Lordship will find this in Annexure 6, page 41. It's in the form of a very simple application. This was drafted by one of the petitioners. And it is pertinent to mention that at this point, no legal consultation was sought. And therefore, although they intend to go for appeal of this matter, the language employed here was review. And this document is important, Lordship. Allow me to read this. Yes. To Deputy Commissioner Kohima, subject prayer for reviewing of judgment and order by GB's Court, Kohima Village, with regard to land dispute at Duck Lane, Fecheke, Kohima, with reference to Kevisen Nazachu and Party versus N. Lao Solo. Sir, with reference to the above cited subject, we would like to state that these few lines for your kind consideration, that due to land dispute as cited in the above subject, we approach the GB's Court, Kohima Village, where the court initiated the case on 8th June 2019 and announced its judgment. However, we are dismayed and not satisfied with the judgment that was announced. We are therefore left with no option but to seek your office to review the judgment or order of the GB's Court, Kohima Village, and deliver a just and impartial judgment through the District Customary Court, Kohima. We remain grateful to you for your kind and necessary action. Thanking you. And petitioner number 1. Now, the Deputy Commissioner, who is supposed to be aware of the rules, instead of guiding the petitioners to the right forum, now, Lordship, at the bottom, Lordship will find that this matter was endorsed to PA to DC, and thereafter PA to DC has endorsed the same to the Dubashi court. The Dubashi court has adjudicated the matter by even inspecting the disputed land and decided in my favor, Lordship. It was decided in my favor. However, in that same judgment,
Yes.
Lordship, in that same judgment, I was made to pay 50,000 rupees.
50,000 to whom?
To compensate the respondent who has already carried out some constructional activity in my land. After this, the respondent approached the Deputy Commissioner's Court under Rule 31 of Rules for Administration of Justice and Police, challenging inter alia the judgment of the DB's court, on the ground that the DB's does not have the jurisdiction to entertain appeal, as it holds concurrent jurisdiction with the village council.
Yes, yes, which is right.
Yes, but instead of preferring a review petition, this was done before, this was raised before the appellate court. Now, the appellate court, before the appellate court, a date was fixed for hearing. And Lordship knows the provision of Rule 31 that the language of the Rule 31 is such that if the presiding officer sees any doubt in the judgment of the subordinate court, then de novo has to commence. Otherwise, it should enforce and accept that as one of its own. Lordship knows this. Now, there is no clear provision which states that it can quash and set aside the subordinate court's order, particularly when the ground raised is on jurisdiction.
So let's see what the DC said.
Yes. And page 90, Lordship.
90.
Page 90. Lordship will find the operative part in page 91, starting from serial number 1. Married Lordship. The review order of the DB's Court Kohima in poll case number 7, 2019, dated 12/2019 is quashed and set aside on the following grounds. The sale of the joint property by a single individual and descendant, like in the present instance of Mr. Vigetulia Solo and the respondent, is bad in law. Hence, the sale of plot of land by the vendor to the present respondent is void and from the very beginning. Number 2, the claim of the present respondent is hit by ledges, and there was no complaint from the respondent when appellant carried out developmental works in 2008-9, but only in 2013. Number 3, the plot of land brought by the present respondent is marked at 120 into 68 square feet without any demarcation. This plot of land could be anywhere in any part of Duck Lane, Kohima, which without defined boundaries, this court is not inclined to acknowledge in the interest of natural justice and fairness to the concerned. Number 4, Rule 31 of the Rules for Administration of Justice and Police in Nagaland states that an appeal shall lie from the decision of Mauzadars, Gambaras, Chief Headmen of Khels, Dubachis, or other duly organized village authorities to the tribal court whenever constituted or otherwise to the Deputy Commissioner or his assistant. If the court sees reason to doubt the justice of the decision, it will try the case de novo or refer it to the Panchayat as above. There is no provision for review of the judgment and order decision of the lower court made in this Rule 31. The review order decision of the DB's court, Kohima, is barred by the principle of coram non judice, which is in the instance case, the DB's court, Kohima, cannot derive jurisdiction apart from the statute of the Rules for Administration of Justice and Police in Nagaland. The DB's court had neither availed the provision of trying the case de novo or refer it to Panchayat. Number 5. This is not so much relevant, Lordship. So, basing on this ground, on these reasons,
the DB's court judgment was quashed.
The DB's court judgment was quashed. However, Lordship, I have submitted one counter affidavit to the petition, to the appeal memo filed by the respondent, and I have given my grounds, my reasons in that counter affidavit. So, besides this jurisdictional issue, my grounds, my reasons were not taken into account while deciding this matter. And therefore, since there was material irregularity, I have annexed my counter also in page 81.
Page 81. This is before the DC.
This is before the assistant to DC. The DC has referred the matter to assistant to DC. Assistant to DC has taken up. However, it was the impression of the petitioner that the hearing is to determine whether it will go for de novo or not. However, an argument was advanced in that line. However, when the order came out, it was a full judgment determining all the supposedly all the issues in the dispute. But my points were not taken into consideration at all.
Yes.
Thereafter, aggrieved by this decision of the assistant to DC, I approached this honorable court by filing a revision petition. And Lordship will find the decision of this honorable court in page 93, annexure 11.
Says your revision.
May I take your Lordship to the 11 paras?
Yes. Against this order of 10 June. 10
Against,
June, isn't it?
Yes, Lordship.
10 June 2022.
10 June 2022 in Civil Appeal 2 of 2019. Now, Lordship, may I kindly see para 10, page 97.
Yes.
After going through the judgment and order dated 10/6/22 passed by the learned assistant to DC Kohima, this court is of the view that it may not be necessary for this court to discuss all the issues dealt with by the learned assistant to DC Kohima. The pertinent question is, however, I continue, Lordship. The pertinent question is, however, arises for the consideration of this court is whether the DB's court had the power to review the order passed by the GB's court or to sit in an appeal over the said decision. So on this very limited issue, instead of going into any other grounds, this honorable court has passed its judgment. The operative part is in page 106, para 21. Para 21, in the light of the discussion made above and having held that the DB's court under the rules has no power to review or sit in an appeal over the decision of the GB's court, the judgment and order dated 10/6/2022 passed by the learned assistant to Deputy Commissioner Kohima in Civil Appeal 2 of 2019, questioning and setting aside of the order dated 12/9/2019 passed by the DB's court in poll case number 7/2019 is upheld. 22, the civil revision petition is dismissed. Interim order dated 26/5/2023 accordingly stands vacated. 23, the petitioner, if aggrieved by the judgment and order of 10/6/2022 passed by the learned assistant to Deputy Commissioner Kohima, can avail the remedy of appeal as provided under the rules, if so advised, in accordance with law. Now, pursuant to this judgment, I have filed an appeal, the second appeal before the Deputy Commissioner under Rule 29(1) of the rules.
Okay.
And then hearing took place, and the decision, the impugned decision was rendered by the Deputy Commissioner, learned Deputy Commissioner on 11 March 2025.
Where is that?
Now, before going to this, to the relevant portion, may I take your lordship to my, to the grounds that I have taken before this, the Deputy Commissioner.
You take the court to the impugned judgment order first.
Lordship.
Annexure 1.
Annexure 1, page 20. Relevant portion is from 29 onwards.
Yes.
Para 7, Lordship. Married, Lordship. On the instant appeal matter, the counsel for both the parties were heard, and the following are the observations of this court. A, in regard to the question of the proceedings and the judgment passed by the assistant to DC Kohima in Civil Appeal 2 of 2019, this court has gone through the records and observed that the assistant to DC has provided all opportunities to exchange pleadings, and it was after hearing the learned counsels for the parties that the learned assistant to DC has delivered the judgment and order dated 10/6/2022. Hence, the grievance regarding submission of the respondent appellant has not been taken into consideration by the learned assistant to DC while passing the order dated 10/6/2022 does not arise. The Honorable High Court, in its judgment and order dated 10/6/2023, also observed the same view that all opportunities were afforded to the parties, and it will be an exercise in futility to direct the assistant to DC to try the case de novo when the DB's court itself lacked the inherent jurisdiction to try and decide the case appealed against. Number B, in regard to the jurisdiction of the DB's court, Kohima, to review the decision of DB's court, Kohima Village, Under the rules for administration of justice and police in Nagaland, it is clear that the DB's court is not empowered under rules to review or take up appeal over the decision of the GB's court. The GB's court and the DB's court exercise concurrent jurisdiction in trying and decide cases under the rules for administration of justice and police in Nagaland. Therefore, the DB's court are not court of appeal over decisions delivered by GB's court. The Honorable High Court, in its order dated 16/10/2023, has considered the same view that it is well settled principle of law that a defect in the jurisdiction of the court goes to the root of the matter and strikes at the very authority of the court to pass an order. While citing several decided cases in regard to the jurisdiction of the DB's court and validity of orders passed by the court without having jurisdiction, the High Court, in its judgment and order dated 16/10/2023, stated that the order dated 12/9/2019 passed by the DB's court, Kohima, is without jurisdiction. However, this honorable court does not find any infirmity in interfere with the judgment of an order dated 10/6/2022 passed by the assistant to DC Kohima to quash and set aside the order of the DB's court. Both these are on jurisdiction. Number C. Regarding the decision dated 8/6/2019 of the GB's court, Kohima village, it is observed that the GB's court, Kohima, while deciding the case, has taken into consideration facts and circumstances of the case. The land is a common property of the lineage of 3 grandfathers, and the sale of the land to the respondent by the descendant of 3 grandfathers is not disputed or questioned. The said order directed directed Mr. V. Ketulia Solo and other descendants of late Well Hulia Solo, one of the 3 grandfathers of the Solo clans referred to in the case, to give 1 piece of land to the respondent to pay the respondent and the interest of 12 years along with the principal amounting rupees 4,75,600. It is the submission of the respondent that under the customary law, a common land property cannot be sold to an individual, even though having its share without obtaining consent from all shareholders of the property. On the other hand, the appellant has also acknowledged the fact that the land in question is a common property, and the sale of the land to the respondent by the descendant of the 3 fathers is not disputed or questioned. That by the judgment and order dated 10/6/2022 of the assistant to DC, the sale of the joint property by a single individual is bad in law, and hence the sale of the plot of land by the vendor of the appellant is void from the very beginning. Lordship will find that my submission was not considered at all. This was the submission of the respondent. Number D. The senior counsel for the respondent submitted that the assistant to DC and the GB's court basically derive its decisions on the undisputed and admitted facts of the land in question is a joint common property belonging to the lineage of 3 grandfathers, that no illegality is being committed on by either of the lower courts. The senior counsel also submitted that the appellant has not filed a complaint against the necessary party without whom no effective order can be passed. However, considering all the appellant has been given full relief by the GB's court in the decision, the appellant in the instant matter cannot be considered to be aggrieved party persons, as decision of the GB's court was imposed on the vendor seller. In support of the senior counsel's submission, the following case laws are relied upon: 1, 2, 3. These are again a reproduction of the submissions made by the learned senior counsel. Number E, it is the submission of the counsel for the appellant that the sale deed through which the respondent attempts to establish title over the land in question has no indication of land measurement area, for which the area of the land in question cannot be determined. On the other hand, the senior counsel for the respondent submits that the so-called sale deed as claimed by the appellant cannot be considered to be a valid because it was prepared by the appellant himself, claiming to have purchased the land from Vikatulia, that a valid sale deed must be executed by the seller, vendor of the property in favor of the purchaser to acknowledge the transaction of sale of property. In order to claim right, title and interest over the property, the sale deed requires to be registered under Section 47 of the Registration Act by paying appropriate stamp duty. Without such registration, no right, title, interest of an immovable property can stand transferred to the purchaser. To support this argument, the senior counsel has relied on the case laws, and then the case law is reflected here. This is again ended with the submission of the learned senior counsel. My submissions were not considered again. If the counsel for appellant also alleged that the decision of the GB's court, Kohima village, has violated the rules for administration of justice and police in Nagaland, as there is no indication of the requirement of at least 3 respectable witnesses present while deciding the case, to which the senior counsel for the respondent submitted that the presence of the 3 witnesses is a mere directive of the GB's court and not mandatory, and the non-presence of the 3 witnesses do not nullify the decision of the GB's court, because it does not oust the power of the GB's court for adjudication. At the most, non-presence of the 3 respected witnesses would amount to only an irregularity but not illegality. It ended with senior counsel submission. Number G, in regard to the period of limitation to file a case before the GB's court, the counsel for the appellant submitted that there is no provision under the rules for administration of justice and police in Nagaland with regard to limitation period, for which the senior counsel for the respondent submitted that the statement was false and misrepresentation of law, because the Limitation Act 1969 is applicable in Nagaland, and affirmed his submission to the Honorable Court in case of Madan Kaba and others versus R. Temjin Kaba Au and another in this Honorable Court's decision. My full submission was not recorded here. Number 8, this is the operative part, Your Lordship. Heard the counsel for the parties at length on perusal of the records. This court is of the opinion that the pertinent issue to take into consideration under Rule 29(1) is to see whether there is any infirmity in the judgment and order dated 10/6/2022 passed by the Assistant to Deputy Commissioner in Civil Appeal number 2 of 2019, while quashing and setting aside of DB's court order dated 12/9/2019 in poll case number 7 of 2019, for which this court has observed that under the order passed by the GB's court, Kohima village can only be appealed or reviewed before the Deputy Commissioner and his assistant. And there is no provision under the rules for administration of justice and police in Nagaland as amended for the DB's court to review orders passed by the GB's court. This was already decided by this honorable court in the earlier revision petition that I filed. And this honorable court has directed that I should advise, I should prefer an appeal before the correct forum and raise the issues before the right forum. Now under 29(1), a second appeal has been preferred before the Deputy Commissioner's Court. And Lordship knows that in second appeal, substantial question of law has to be decided Now, only on a technical consideration that has already been decided. My appeal has been dismissed. And besides, as I have already read shown your lordship that my submissions were not taken into consideration at all. My submissions I have annexed, I have reproduced in my petition, my
The entire
submissions.
finding is only 8, para 8, isn't it? Para 8, because the
Yes.
others are all recording of submissions.
More or less recording of submissions. It can never be considered as an observation of the court or as ratio of the court. The ratio is only para 8, lordship.
No, but see para 7.
Yes.
Yes. A, B, C. There.
Yes.
Of course, the court has said all opportunities were afforded to the parties, etc. See also, regarding the merit of the case,
yes,
the court has gone into that the land is common property of the lineage of 3 grandfathers, whereas 7C.
7C.
The appellant has also acknowledged the fact that the land in question is a common property.
Yes, lordship, but my submission that elders were being consulted, this was not taken into account. Now again, if the land belongs to 3 lineage, then I belong to 1. When I'm not consulted and the other two sold the land, assuming that is the situation, that can the joint property is sold by a larger number of the descendants, and without consulting some descendants, will that hold? Will that be legal, and property sold by a lesser number, presuming? Will that not be legal? Will that not be legal, lordship? They stand on the same footing, if at all, that is the submission of the other party. And Kohima village land certification document, none of these courts have taken this into consideration, have decided the legality of this document into consideration while adjudicating, because rightly or wrongly, it falls under the jurisdiction of the Kohima village jurisdiction. And KVC is a statutory body, lordship. Although there may not be any legal provision where it empowers the KVC to grant land certification document.
Any case law?
Yes, lordship. May I present my grounds, lordship, before going into that, lordship? Lordship will find my grounds in para 8. Page 18, Lordship, I'm sorry. I'm aggrieved because my appeal has been solely on a technical ground, being dismissed. And Lordship, it is in the judgment of the DC as well as in the judgment of assistant to DC, they have stated that the Dubashi does not have the power, the DB's court does not have the power to review or either sit on appeal. However, as I have stated earlier, Lordship, firstly, the petitioners approached the Deputy Commissioner. Deputy Commissioner, on seeing the petition, on seeing the application, himself referred that review application, the application for reviewing,
to the
PA. To the PA to DC and eventually to the DB's court. And against their own action, now it is the decision of both the assistant to DC and DC that since they don't have the power, you don't have a case. Now, Lordship, that is one of my main ground.
Essentially, now the appeal under Rule 29
Yes.
was an appeal against the GB.
Appeal against
Against the GB's order. No, assistant to DC.
Assistant to DC,
Assistant to the
Lordship.
DC's order.
Yes. And although it's in the belated stage now to go into that, Lordship, but there is the procedure is already wrong by the DC himself. Lordship, again, in the decision of the DC, particularly at para C, 7C, all opportunities has been given to both the parties. That is the decision given, but before the assistant to DC also, opportunity of adducing evidence, material evidences, as well as bringing all the material witnesses for examination, that was not done because de novo has never been conducted.
Yes.
So, Lordship, basically in all these forums, proper evidence was not taken. Now, coming back to my
Before
ground.
the assistant to DC also, evidence not adduced.
No. And while saying so, I must state that only before the Dubashis, both the parties appeared, and then on a later date, they went for the disputed area inspection, and then only after that decision was taken. So, considering that...
no, but that DB one is irrelevant now.
Lordship, I'm just stating that only before the DB, proper evidence has been adduced. Yes. And
in the first place, DC could not have endorsed it, actually.
Lordship, that was also, Lordship will find that in the earlier, this court's decision also, this court has made an observation in that regard, stating that DC should have taken up herself, or himself, or give proper guidance. Now, my Another ground that I'm taking is that when this matter was referred for appeal, when I was advised to go for appeal before under 29(1), it is to ensure proper adjudication of matter. It is only to ensure proper adjudication of matter, but this was not done so before the Deputy Commissioner. Number three, that the Deputy Commissioner has failed to exercise the jurisdiction vested in him by law by omitting to decide the matter on merits. The Deputy Commissioner has abstained himself from examining the substantive issues and evidences and the contention of the parties. Now, when I'm saying that I've purchased this land lawfully before the respondent, now the legality of my purchasing of that land, that was not decided. I've consulted. The seller has already consulted the elders and they are signatories. That was not taken into consideration. Now, in that regard also, this one Tignoville, he has already offered the land, knowing fully well that the land was already purchased by me. He approached me to buy the adjacent land also. When I refused, purportedly, the entire land was sold to them, but in their sale deed, whether my portion has been purchased by them or not, nothing has been indicated. It's just the claim. All these were not taken into consideration. And whether, if going by their claim, by the claim of the respondents that the descendants of the three grandfathers has sold the land to the respondent. Now my lineage of that descendant was not consulted. Now the legality of that has to be determined. Your Lordship knows that this nature of land dispute, it involves transfer of property, Contract Act, and then Limitation Act also comes into play. When all these civil laws, which are already in place here in the state of Nagaland, this were not at all taken into consideration, the prevailing law of the land. And as far as limitation is concerned, there is one portion where in the impugned judgment it has been mentioned that about delay in leges. Property was purchased in 2007. The respondent started working in 2008. Now before the GB matter was instituted in 2019. So immovable property, in order to file a case, the limitation is 12 years. Even in that case, 12 years has not expired. Even otherwise, there was continuous cause of action arising because of my objection raised against the forceful occupation and constructional activities. Lordship, I may be permitted to present some case laws. Lordship, in this case relates to the language of 31. I want to draw your Lordship attention to Rule 31.
Rules for administration of justice.
Permit me to read, Lordship.
Yes.
31. An appeal shall lie from the decision of Mauzadar, Gambura, Chief Headman of Khels, Dubashis, or other duly recognized village authority to tribal court, whenever constituted or on otherwise, to the Deputy Commissioner or his assistant. A record shall be made of the matter in dispute and the decision of the village authorities. If necessary, the court shall examine the parties, and if the decision appears to be just, shall affirm and enforce it as one of its own. If the court sees reason to doubt the justice of the decision, it will try the case de novo or refer it to Panchayat as above. Lordship, this provision is very clear that the decision, if the decision cannot be questioned, set aside, that's the literal language employed here. And even if the Dubashi's judgment order is illegal because of the jurisdiction, without going to de novo, the case cannot be adjudicated. If at all, the case is to be heard. There is only two options here in Rule 31, Lordship. Either accept it as one of its own, this was not done so, or when the presiding officer sees any doubt, then de novo should commence. There is no other option left to the presiding officer. And Lordship may kindly see para 12 and 13 of the judgment that I'm relying on, Padma Sundara Rao and others versus State of Tamil Nadu and others. Para 12 and 13.
Yes.
14 as well, Lordship. When the language is clear, then the court should follow it. 12, the rival pleas regarding rewriting of statute and casus omissus need careful consideration. It is well settled principle in law that the court cannot read anything into the statutory provision which is plain and unambiguous. A statute is an edict of the legislature. The language employed in a statute is the determinative factor of legislative intent. The first and primary rule of the construction is that the intention of the legislation must be found in the words used by the legislature itself. The question is not what may be supposed and has been intended or what has been said. Statutes should be construed not as theorems of Euclid, Judge Learned Hand said, but words must be construed with some imagination of the purpose which lie behind them. Number 13, in Dr. Venkatachalam versus so-and-so, it was observed that the court must avoid the danger of priori determination, the meaning of a provision based on their own preconceived notions of ideological structure or scheme into which the provision of the to be interpreted is somewhat fitted. They are not entitled to usurp legislative function under the disguise of interpretation. Number 14, while interpreting a provision of the court only interprets the law and cannot legislate it. If a provision of law is misused and subject to abuse of process of law, it is for the legislation to amend, modify, and repeal it if deemed necessary. Only that much I'll read for this Honorable Court. So although the statute is very clear, the language is very clear in 31, de novo has not been conducted. Again, I'm relying on
31 also says that if necessary, the court shall examine the parties. And if the decision appears to be just, shall affirm and enforce it as one of its own.
Yes.
Even if it's not de novo. If necessary, the court shall examine the parties. So the parties were examined or not?
Lordship, parties were not examined. Lordship, my respectful submission is that my understanding of the statute here is that that is before sending the case to de novo. Before that also, it can be done so if the court chooses to do so.
No, only if the court sees reason to doubt the justice of the decision.
Yes.
If the court sees reason to doubt the justice of the decision, then it will try the cases de novo or refer it to a panchayat, as above. So if the appellate court does not see reason to doubt, then
it should enforce the DB's court judgment, which is in my favor, Lordship.
If the court sees reason to doubt the justice of the decision.
Only if it sees doubt, then it is in their favor. But still, instead of questioning, only de novo can commence.
It will try the cases de novo. Okay. Yes, then?
R. Nagaraj versus Rajmani and others. Lordship, I'm relying on para 21.1. Where procedural law cannot override substantive law, Lordship. This is in regard to that. 21.1, may I read, Lordship?
Yes.
It will be useful to refer to certain judgments of this court on violation of procedural law, which are as follows. 1, so-and-so versus so-and-so. 26, laws of procedure are meant to regulate effectively, assist and aid the object of doing substantial and real justice, and not to foreclose even an adjudication on merits of substantial rights of a citizen under personal property or other laws. Procedure has always been viewed as the handmaid of justice and not meant to hamper the cause of justice or sanctify miscarriage of justice. Number 2, Kailash versus Nanku, 28, all the rules of procedure are the handmaid of justice. The language employed by the draftments of procedural law may be liberal or stringent, but the fact remains that the object of prescribing procedure is to advance the cause of justice. In an adversarial justice system, no party should ordinarily be denied the opportunity of participating in the process of justice dispensation unless compelled by express and specific language of the statute, the provision of the Code of Civil Procedure, or any other procedural enactments ought not to be construed in a manner which would leave the court helpless to meet extraordinary situations in the end of justice. The observation made by Krishna Iyer, justice in so-and-so, next para, Lordship. The morality of justice at the hands of law troubles a judge's conscience and points an angry interrogation at the law reformer. The procedural law so dominates in certain systems so as to overpower substantive rights and substantial justice. The humanist rule that procedure should be the handmaid, not the mistress of legal justice, compels consideration of vesting and residual power in judges to act ex debito justitia, where the tragic sequel otherwise would be wholly inequitable. Justice is the goal of jurisprudence, procedural as much as substantive. In State of Punjab versus Shamlal Murari, the court approved in no unmistakable terms that the approach of moderating into wholesome direction what is regarded as mandatory on principle that procedural law is not to be tyrant but a servant, not an obstruction but an aid to justice. Procedural prescriptions are handmade and not the mistress, a lubricant, not a resistant in the administration of justice. In Gyamshandas versus Dominion of India, the court reiterated the need for interpretation of part of the objective law dealing with the procedural alone is in such a manner as to subserve and advance the cause of justice rather than defeat it, as all the laws of procedure are based on this principle. Number 3, Sugandhi versus by Legal Years versus P. Rajkumar. It is often said that procedure is handmaid of justice. Procedural and technical hurdles shall not be allowed to come in the way of the court while doing substantial justice. If the procedural violation does not seriously cause prejudice to the adversary party, court must lean towards doing substantial justice rather than relying upon procedural and technical violation. We should not forget the fact that litigation is nothing but a journey towards the truth, which is the foundation of justice, and the court is required to take appropriate steps to thresh out the underlying truth in every dispute. Therefore, the court should take a lenient view when an application is made for production of documents under Subrule 3. So, the same principle, I'm invoking the same principle in the present revision also before this honorable court, that my case has been dismissed solely on procedural ground. Lordship, I'm also, in my petition, I'm also making a prayer that since the instant case involves, as I have stated, contract law, property laws, so on and so forth, limitation laws, it squarely falls within the jurisdiction of a regular civil courts, which have the competent jurisdiction under CPC. And considering that both the assistant to DC and the deputy commissioner has miserably failed to adjudicate the matter properly on merits, and they have failed to give the opportunity to the parties to adduce evidence as well as to bring witnesses to adjudicate the matter. It is in the interest of justice that this matter may be transferred to a regular court, Lordship. And Lordship knows that as per Nagaland Judicial Services Rules 2006, where the nomenclature has been prescribed, the role of the judiciary has been prescribed through not through a notification. Lordship, the jurisdiction of Deputy Commissioner is the same as the District and Sessions Judge. And therefore, taking the circumstances cited into account, the matter may be prescribed to, maybe transferred to a regular court for proper adjudication of the case. And Lordship is also well aware that in earlier cases also, this Honorable Court has allowed the transferring of cases from the executive side to the regular courts. Lordship, for this also, I'm presenting one ruling. There are 4 and 5, Lordship. Married Lordship.
This is on what point?
On the point that the matter which is pending adjudication before one court to be transferred to a regular court. Can you kindly see paragraph 4? Married Lordship.
Yes.
Further, being aggrieved and dissatisfied with the order of the Additional Deputy Commissioner dated 17/5/2017, the respondent filed a revision petition under Rule 32 of 1973 rules, which was registered as Civil Revision Petition 12 of 2017, but this court, by judgment and order dated 25/5/2018, this court remanded the matter back for reconsideration by questioning and setting aside of the order dated 17/5/2017 passed by the Additional Deputy Commissioner. In doing so, this court was also of the opinion that the Civil Appeal number 1 of 2015 should be adjudicated by a competent court in accordance with law, and accordingly, the Civil Appeal number 1 of 2015 was transferred from the Court of Additional Deputy Commissioner Kohima to the Court of Civil Judge Senior Division Kohima, whereby a time frame of 6 months was fixed for disposal of the said civil appeal. So, Lordship, the other paras are also in relation to this. So,
okay. 23/119 reviewed earlier.
So in earlier occasions also, this Honorable Court has permitted transferring of cases from either Additional Deputy Commissioners, assistant to DC's court to regular courts. Unless your Lordship needs any more clarification from my side, that's all for my submission.
I think that should do. Yes.
Your Lordship.
Yes. It can be remanded back also.
Your Lordship,
fresh consideration. Anyway, yes.
Yeah, it depends on the situation.
Yes.
And facts and circumstances of the case. First, I will take your Lordship to page 52 of the appeal memo. I would like to take your Lordships to the facts of the case. And in this, at page 52, starting from page 51, this is my appeal memo under Rule 31 to the Assistant to Deputy Commissioner, the first one. Then in paragraph 2, at page 32 of this appeal memo, page 52.
Page 52.
Page 52, in paragraph 2, brief facts of the case. The brief facts of the case is given. May I read, Your Lordship?
Yes.
That the brief facts of the case is that the present appellant purchased a plot of land situated at Nagaland, Kohima, Nagaland for a sum of ₹80,000. The land was an ancestral property jointly possessed by 3 grandfathers, namely late Well Solo, late Funio Solo, and late Nivile Solo. After the death of the three grandfathers, the land was inherited by the descendants and jointly possessed by them. Sometimes in 2007, the descendants of the three grandfathers decided to sell the plot and approached the appellant to purchase the said plot of land, being a close relative. On being approached, the appellant, along with some descendants of the three grandfathers, visited the site and thereupon agreed to purchase the said plot of land. On 30/9/2019, the appellant, along with the descendants of three grandfathers, gathered at the residence of one of the descendants, namely Mr. Nipro Solo, and being agreed by all to sell the land, the appellant purchased the said plot by drawing an agreement dated 30/9/27, signed by one descendant representing each of the three grandfathers. The purchased amount was also shared among themselves on the same day in the presence of the appellant. That the plot of land is bounded by drainage in the south and west, border road in the east, and north, Lao plot in the north. After purchasing the land by the appellant, sometime in the year 2008-2009, the government proposed to revive the border road, and being the landowner, the contract for construction of retaining wall with RCC columns and beams was given to the appellant. The appellant took the contract and raised a concrete wall on the entire stretch of his land in support of the road. When all this development took place, there was no claim/dispute from anyone. Only sometime in the year 2013, that is after 6 years, the respondents came to the residence of the appellant and told the appellant that the plot of land below the road was purchased by him from Mr. Vigatule Solo, one of the descendants and grandson of late Welhule Solo. Therefore, the appellant had told the respondent to approach their vendor Vigatule Solo, since the land was a common property of, and according to Angami Naga custom, a joint/common ancestral property of a clan cannot be sold by an individual. Lordship, this is very relevant. The appellant had purchased the whole land after drawing an agreement signed by each descendant of the three Solo's grandfather, and there was no dispute/claim from any other descendants of the three grandfathers. The respondents remained completely silent of his claim over the plot for some years, and only sometime in 2016, an accident occurred at the site of the appellant due to some drunk-driven youths and rammed into the rented house owned by the appellant. When the appellant and his son went to the site to see and assess the damage caused due to the accident, the appellant happened to meet the respondent, and the respondent, again claiming that he had bought the land by pointing it towards the plot. Therefore, the appellant again reminded the respondents to approach his vendor to settle the matter among themselves. Thereafter, the appellant started construction work by erecting concrete pillar for RCC building over the plot. The respondent did not make any whisper even on completion of the first and second phase of the work, and only sometime in the year 2018, when the appellant started the third phase of the work, the respondent again started disputing and claiming over the plot and lodged a complaint against the present appellant before the GB's court, Kohima village, on the basis of an affidavit signed by the present respondent as purchaser and Mr. V. Gitule Solo as vendor, alleging that a plot of land measuring an area of 120 by 68 square feet situated at Techike, Nagaland has been purchased by him from V. Gitule Solo, grandson of Red Will Solo, on 28/2/2007. The respondent had also produced a land ownership certificate dated 6/11/2018, issued by Kohima Village Council in furtherance of his claim of ownership of the land. The same was obtained dishonestly by the respondent since the land is under dispute. The certificate was also issued without inviting, should have been inviting, any claims and objections, and without any verification, and therefore does not confer any binding force. To this effect, the Autonomia Council Kohima Village had also issued a clarification, stating that the certificate was issued only to show that the land was not under any dispute and not for the purpose of supporting any case. Then, that is the brief facts of the case. And these facts has not been denied. The bare facts has not been denied. And for that purpose, now we have to see the objection filed by the respondent, present appellant. Page 84. Page 84, starting from paragraph 3.
Paragraph 3.
Paragraph 3, starting from paragraph 3. That in regard to the contents of paragraph 2 of the appeal, as far as it concerns the joint ownership of the land in question by three grandfathers, namely late Belhule Solo, late Puni Solo, and late Nivile Solo, it is not denied. It may be mentioned that the said land was purchased by the respondent from one Mr. Vigitule Solo, son of late Kasu Shehe Solo, one of the descendants of the three grandfathers who owned the land. Before the land was sold to the respondents, the vendor, that is Vigitule Solo, had consulted with the elders. The said land had been purchased by the respondents by executing a sale deed dated 28/2007, which was much earlier than the date the appellant has been claiming to have made the purchase, as the appellant has claimed to have purchased the said land by agreement dated 30/9/2007. Moreover, in addition to the said controversy, nowhere in the said documents indicates specific measurement of land being transacted. Therefore, it is not known as to the size of area which the appellant had purchased. Let me pause for a moment here. Now, initially the appellant contended just now that the game we are playing is that we have a boundary, and without measurement, we are playing with the game. They are playing with the game. They are playing the game. They have 120 by 68 area. From where to start? It says located at Nagaland. Therefore, the assistant DC has rightly says that without showing a boundary, this area can be anywhere in any part of Nagaland. Now, when there is a boundary, that is sufficient. We don't have to give the area of the land if there is a boundary. Now, if only area is given, land and breadth, from where to start? Where is the starting point to measure the area, the land and breadth. And that is what the present petitioners are playing. That is their game. Then, if you go further in paragraph 3 of their reply, they have not denied
They have not denied that there are 3 grandfathers.
yes, and then without let me go to my this again. I 52. Yeah.
Page 50.
Specific statement at page starting from 52. Page 53, in the middle portion, only sometime in the year 2013, the respondents came to the residence of the appellant and told the appellant that the plot of land below the road was purchased by him from Mr. V. Getule Solo, one of the descendants and grandson of late Getule Solo. Therefore, the appellant had told the respondent to approach the vendor since the land was a common property and according to Angami custom, a joint/common ancestral property of a clan cannot be sold by an individual. This is not denied. Now your Lordship knows very well that in suits or even in petitions, when an allegation is made, and more particularly in cases of land disputes or nature of cases like this, when an averment is made, and if the opposite party denies it, he has to deny specifically, not in general. He has to deny, and then he has to say that why it is not like this, it is like this. Now, consultation, their contention of consulting 2 elders, that is not sufficient. And the dispute revolves only on this. The undisputed fact is that the land belonged to 3 grandfathers, inherited by their descendants, and as per custom, Angami customary law, an individual cannot sell the ancestral property of that one. Now, in my case, there are 3 descendants of the 3 grandfathers came to me and sold to me. Now, therefore, they also has not disputed that. Therefore, there is no question of any issue. What is the issue? And where is the question for the need of adducing evidence? All those are, and then question of adducing evidence. Now it is not their point, or it is not their ground that since I prayed the court to allow me to produce my evidence, but the court has rejected, there will be a genuine ground. But that is not their case. And if they bring any witness and if they were not examined, then that also would be a genuine ground. And non-framing of issues, when the issue is known to both the parties, non-framing of any issue is not fatal to any suit. The court can proceed with that, and the court can give a finding on the admitted facts of the case. Therefore, since that is the basic dispute, which I have stated in my paragraph 2 in the Civil Appeal number 2, 2019, filed before the Assistant Deputy Commissioner Kohima. The Deputy Commissioner, Assistant Deputy Commissioner has rightly decided the decision. Now after that, they approached the High Court. But before coming to the High Court, they approached the Divorce Court. Now they are only pleading on de novo trial, which is baseless, in fact. Now, DB's court, whether for review or for appeal or for a fresh suit, the DB's court has no inherent jurisdiction. It is not only lack of jurisdiction, it is inherent lack of jurisdiction. When it is inherent lack of jurisdiction, then whatever is done by that court is a nullity. It does not exist. It is null and void. Therefore, the contentions that they were not heard, that it was not considered for de novo trial, those are in fact baseless. There is no grounds for a de novo trial. When a court lacks inherent jurisdiction, how a court can pass an order for a de novo trial? On the other hand, Your Lordship knows better now, Rule 31, as Your Lordship says, when there is a doubt of justice, it can refer the matter to, it can go for de novo trial. But when it is fair, then it can affirm it. Examining the parties is optional. If
necessary.
Yes, if necessary. If not necessary, then the court can uphold the decision of the Ganbura. Therefore, since the Assistant to DC finds that despite few illegalities before the Gamburas, he upheld that one because the Assistant to DC also says one point is that as per Angami custom, this a common property cannot be sold by an individual.
That is the finding of Assistant to
Yes.
DC.
Another is
sale of joint property.
Yes. Another is delay. Now, the first appellate court also says delay. Yes, there is delay because now the claims of the petitioner is he purchased before me in February. First in time. I'm in September. So now, after how many years he approached the divorce court? After in 2018. So now there is delay to go to divorce court or to go to any court because if the present petitioner wants to challenge my purchase, he has to go for a declaration of title and for possession because I'm already in possession by erecting RCC constructions, RCC posts for building. And so the aggrieved party or the present petitioner has to approach a civil court for a declaration of title and for possession. And for declaration of title, limitation is 3 years. Now, the assistant to DC says there is delay, but that was not the basis of the dismissal of their appeal, their first appeal, because the assistant to DC has upheld the decision of the Gamburas, because that is in their favor. Otherwise, if we apply the principle of delay, they will not even get that one. Now, the other interesting point is the so-called seller, Vigetule Solo. He was asked, he and his family trees, I believe, they were asked to give an alternative plot of land or money with interest for 12 years, amounted to 4 lakh something. It is directed against the Vigetule, the purchaser. Now, Vigetule is not aggrieved by that. He is not aggrieved by that order. There is collusion, clear case of collusion between the present petitioner and Vigetule Solo. There is collusion between them. Otherwise, why should not Vigetule approach the court against the decision of the Gamburas, saying that no, this is my land. I have consulted these two elders before selling. They have agreed. So how can I be made to pay him rupees 4 lakhs for 12 years interest and or to give him an alternative plot of land? But there is collusion. That is why this Vigetule Solo is keeping quiet. Okay, you proceed, and if you succeed, well and good.
Okay, let's see that GB's order again.
Page 78 also there.
40, page 40. Translated copy is page 40, isn't it?
Yes. Yes.
Okay, Vigetule Solo shall give one piece of land.
Upon hearing the parties and on verifying the land, this is.
Yes, I think this is the GB's order.
Oh,
yes.
Verifying the land, Division Azatsu and party, both the land at Pechike Nagaland, below the road, from Mr. Vigetule Solo, but lineage of the three grandfathers had sold the land to Enlao. Therefore, Kohima village GB's court gives the following order. Vigetule Solo and the descendants of his grandfather will give one piece of the land to Kivisen and party, either as per earlier agreement or more than that. 2. If the first order cannot be abided by, they shall pay interest and principal for 12 years, amounting to rupees 4,75,600. They bought it at 58. Now, this is directed against Vigetule. He is keeping quiet. He is not aggrieved. If that is so, then how the present revisionist can come against me? And in fact, Vigetule Solo has misled them. If at all they really purchased, if at all they really gave him rupees 58,000, he was misled. But they are not against him. They are not against Vigetule Solo. Or they are not against the other three descendants of the three grandfathers who sold the land to me. They are not even aggrieved by that one. Because it is an admitted fact. Therefore, therefore, the order passed by the first appellate court, assistant to DC, is there is nothing illegality or there is nothing wrong about it. And that is just and fair. That is, justice has been done because now the order of the GBS is in favor of the present appellant, present petitioners. How they are aggrieved by that? Totally in their favor. So in fact, they are not an aggrieved person. They are not an aggrieved party. On the other hand, there is collusion. Now the picture is clear. The picture is clear. There is collusion. You proceed, and if you get it, well and good. If not, okay, I'll give you your 58,000.
Why he doesn't want that alternative plot of land? The direction is to this Vikitule,
Yes.
to give another plot of land or to pay you back with
Lordship,
interest.
Yes, I was a party to the dispute. At this, before the GBs, Vikatuli was not a party to the dispute. Besides,
He is
when
the complainant, Your
Lordship,
Lordship.
the fact is that when the petitioners purchased this land, the disputed land, there was no road connectivity in that area.
There was,
However,
but it was not good because that was a long
this
time.
was
road.
in the lower part of the
Yes.
Duck Lane New Market.
No,
So-
as the learned senior counsel
Yes.
has pointed out, this GB's order which we read just now
Yes.
is entirely against this Vikitule.
Yes.
Lordship,
He has to give alternative plot of land. He has to pay you interest with interest.
Lordship, my
Anyway, yes.
contention is that
No, just trying to.
I have lawfully
understand.
purchased it, and I do not want any other alternative land, or for that matter, for the compensation that has been prescribed by the GBs.
And
When I'm the lawful owner, why should I take another land, Lordship,
Okay.
because of which
Which land they want? They want in the affidavit as page 32, which was first shown by the present learned counsel. This is written by the purchaser, not the seller, to the purchaser. And the area is, the measurement of the said land is 120 feet land, 68 feet breadth. Where is the location of land? Is my plot his land? Can we ascertain from this? According to the agreement executed by me, they have sold to me the whole plot of land with boundaries. Now, how do we ascertain this plot of land 120 feet by 68 feet in Nagaland? It can be anywhere, as rightly pointed out by the first appellate court. Therefore, there is no basis even for this appeal. And the learned High Court in the first order in revision 1 says at paragraph 23, the petitioners, if aggrieved by the judgment and order dated 10/6/2022, that is the first appellate court,
Yes.
passed by so-and-so, can avail the remedy of appeal. And therefore, the first appellate court, the order of the first appellate court has merged with the GB's decision, because DB's decision, since it lacks inherent jurisdiction, cannot be anywhere in the picture.
And that has been quashed also.
Yes. And so the learned DC has, in his summing up, after paragraph 8, he rightly said, heard the counsel for the parties shall learn and on perusal of the recourse, this court is of the opinion that the pertinent issues to take into consideration under Rule 29(1) is to see whether there is any infirmity in the judgment and order dated 10/6/2022. He has to see it, not the DB's court. Because in this order dated 10/6/2022, GB's order also is merged with this order, but not the DB's order. Therefore, while challenging this first appellate court's order dated 10/6/2022, the opposite party, the present petitioner, cannot in any circumstances raise what has been raised or decided in the DB's court. And therefore, in the light of the above, in paragraph 9, in the light of the above, the Assistant DC has rightly questioned, set aside the order dated 19/2/2019 and upheld the second appellate court also upheld order dated 10/6/2022, passed by the first appellate court. And from the beginning, all this contains merits of the case also. And the court also finds that there is no dispute about the ownership of the land, about the three descendants, lineage, the land belongs to the three grandfathers. And that the three grandfathers, lineage of three grandfathers sold it to me. And that the other people has no objection, has not disputed, including the present petitioner. The present petitioner nowhere stated that the three descendants of three grandfathers cannot sell it to me, or that selling to me is illegal. Nowhere did this mention. Admitted fact. So, in such circumstances, there is no question of framing issues, there is no question of going for a de novo trial, and your Lordship knows that now this litigation has been going on for some years. The decision, the first court, the lowest court decision is in favor of the present appellant. And although not the proper aggrieved person, the respondent, the present petitioner, is barking at the wrong tree, at me. And under any circumstances, since the present respondent is to be now compensated, there also has to be...
Okay, let's continue at 2. How much longer?
All right.
Yes.
Maybe, Your Worship, I'd like to mention item 18. It's last item. It's likely that the other matter may be coming up in the other court. So, yes, Your Lordship. So kindly adjourn this matter for 18.
18.
Yes, item number 18.
So pass over.
Pass over the matter.
Pass
yes.
over.
Yes.
No, my lord, I've talked with the council. Let it be listed on 26th.
26.
Yes, coming Thursday, as fixed item.
Okay, it's not.
In any case, tomorrow is division bench.
Yes, so on 26th Thursday, I've talked with the council.
Okay.
26?
Yes.
18, okay. Just write down with the consent of the parties list on 26. 26-2, okay?
Oblige your indulgence.
Yeah.
Item number, this is a contempt matter, item number 12. Now, Lordship, this is a time-bound matter, Lordship. The direction was to the Deputy Commissioner Chumukinima to conduct an inquiry. And the judgment, the order of this court is dated 24/7/2025. Now, almost 8 months has passed. No action has been initiated. And I've been informed, Mr. N. Angami.
Yes.
To conduct inquiry.
Yes. No inquiry has been done.
No, Your Lordship, I am not representing the Deputy Commissioner. I am for respondent number 1 only.
So if the matter...
So no one has entered appearance? That
Yes. If the matter can come up on the Thursday, Lordship, because they're all official respondents.
No, in any case, we have to see whether a notice is complete or not.
Yes, Lordship.
That's the thing.
Because the steps was taken...
Did it come up tomorrow? We'll see.
Day after tomorrow is division matter.
Yes, yes.
Day after tomorrow, Lordship, yes.
Item 12, list on, day after will be 19th. 19th, isn't it?
Yes, Lordship.
19th.
And my tenure as VCM is expiring next month, March. That is the irony, Lordship.
19-2.
Oblige, Lordship.
Lordship,
Yes.
can I make mention,
Yes,
Your Lordship?
yes.
Lordship, item 22. Item 22, Your Lordship, I am for the respondent number 1.
Item 22.
22. This matter...
Item 22 is already mentioned, I think.
Oh, no, Your Lordship, item 11, sorry. COP 22. In a hurry, Your Lordship, I am making...
Item 11, yes.
Yes, Your Lordship. Item 11, if 3 weeks time can kindly be granted, my Lord.
To file affidavit?
Yeah, to receive the necessary instruction, my Lord.
Okay, item 11. Learned Counsel Mr. N. Angami appearing for the respondent number. Respondent number? 1. Prays for
3 weeks
time to receive instructions.
Lordship, I am for respondent number 2, 3 and 5.
Moaim Chin appearing for respondent 2, 3 and 5. Same prayer?
Yes.
Also prays
And
for
then
3 weeks
respondent
time.
number 4 is VJMO.
But he's not there today. Learned Counsel for the petitioner, Miss such and such is present. List after 3 weeks.
Lordship, even item 9. Item 9, Your Lordship, there are some development, Your Lordship, there.
Yes, my lord, I was informed that some of the petitioners have been given the benefit. So I'd like to file an IA so that those petitioners may be deleted from the instant contempt petition.
From the main content.
Item 9, you say Learned Counsel for the petitioner, Mr. S. Walling, submits that there has been some developments and therefore he would like to file an IA to delete the petitioners who have already, delete the petitioners who have already got the benefit
Of service regularization.
Of service regularization. So prayers allowed, list after 2 weeks. 2 weeks, yes.
Obliged.
Anything else? Anything else?
Sorry for indulgence, but I beg to 1910. Here, as per the office note, service of respondent 1 to 6 is still awaited. If the matter can come up after 2 weeks, my lady.
Service on respondent number?
1 to 7.
Learned Counsel for the petitioner, Mr.
1 to 7.
Fosikos Fote, submits that service report on the respondents number 1 to 4 is still
1 to 7.
1 to 7 is still awaited. So accordingly, list after 3 weeks, awaiting service report on respondent 1 to 6. 1 to 7. 1 to 6, 1 to 7.
1 to 7.
1 to 7. That's all.
Agreeable.
As per the prayer of the revisionist, they want the matter to be transferred to the regular court side to hear the matter again. And what their intention is to go for the novo trial. From the beginning, now that is their intention. Now, in order to go for the novo trial, first, this is court order. I mean, the second appellate court order has to be set aside. After that, again, the first appellate court order has to be set aside, because from this stage, from the second appellate stage, from the stage of deceased court, the novo trial cannot be ordered, because that will be not his jurisdiction, but it is the assistant DC. If the appeal is to this DC court, then he can. But since in the present case, the appeal is before the Deputy Commissioner, the second appellate court, the second appellate court cannot order for a de novo trial. Only the first appellate court can order for a de novo trial. Now, if that is to be so, if we are to allow the prayer of the petitioner, now we will go back to whether it is the executive side or the regular side, they have to file an appeal again against the order of the first appellate court. Then the first appellate court will hear it. Now after hearing whether the first appellate, the court will set aside the first appellate judgment or not, nobody knows. From there, whichever way the order is passed, either party can come to the High Court again against the order. So it will come here.
No, as far as
go
regular
back,
court is
come here, go back.
concerned,
So
even if this case is allowed or dismissed, that option is always there, approaching the civil court.
yes, that is there. Yes, because litigation. Now it has been going on from 2018, for a long time now. And litigation at some point has to come to an end. And when the aggrieved party has been given relief, where is the reason for continuation of the litigation? It has to come to an end at some point of time. It cannot go on indefinitely. And old age may not be a ground under any circumstances. But the petitioner, the respondent, he is now getting very old, and he wants to clear this during his lifetime also. Although that may not be a factor for any of this order. But that is a fact which I will have to place before the court also. And the relief, now the opposite party can pursue the relief given to him. There is no bar for that. And in that respect, we will not be a party. If they want to file a fresh suit, then they'll be different. But the basis for the claim of the petitioner is his so-called cell deed, which is not a cell deed. That is the only paper which the petitioner has. That is not a cell deed, although they say seller, that is a purchase deed.
That's why from the very beginning I said
Yes.
that this is not a registered document.
Yes.
And neither does it indicate the area or
Yes.
location. Yes.
So, since the matter has to come to an end, and since the revisionist has been given the relief, I pray that this court may be pleased to uphold the decisions of uphold the impugned judgment and order, and close the litigation between the present two parties. That is my humble submission, Your Worship.
Yes, any reply?
Lordship, I may be permitted to give a rebuttal to some of the submissions advanced by the learned senior counsel. Lordship, firstly, as far as the denial of the averments made in the 31 appeal is concerned, Lordship has already noticed that this is not a suit case. This has arisen from GB's court, from a customary court, and then later on DB, and then before the assistant to DC. Now before the assistant to DC, Lordship will find in page 34 of my petition, page 84 of my petition. Sorry, Lordship.
Yes.
Your
Before, pairwise reply.
Yes, in my pairwise reply, I have categorically stated in one that save or except what has been specifically admitted by the respondents in the instant affidavit, all averments made in the appeal memo which are contrary to and inconsistent with what have been stated in preceding paragraphs shall be deemed to have been denied in seriatim. Now I have my version of the story. I am not admitting the version of the respondent in their petition. And since I'm not admitting it, that should be considered that I am denying it. And I have also stated my side of the story, which was not replied to by the respondent before the assistant to DC. So that should also be taken as not denied, since they have not made any reply to my counter, Lordship. Secondly, Lordship have already noticed that my prayer is not for de novo. The reason why I have stated de novo time and again is I'm just indicating where the issue has arisen and where things has gone wrong. But my prayer is simply to quash and set aside the impugned judgment in order, because that was decided without going into the merits. And even if the matter is being transferred to a regular court, second appeal, I understand, and it will be heard on second appeal only. But my submissions, my evidence that has been adduced, that has to be taken into consideration while passing a judgment. And that, since that was missing here, I have preferred this revision petition. And as far as the document regarding KVC issued by the Kohima Village Council is concerned, although admittedly this being a transaction between two parties who does not have the legal knowledge about sale deal. It's more or less an agreement. It's a pact between the two of them. It's a transaction. Consideration has been paid. The two of them, when it comes to contract, the two of them all being adult, there was no coercion. The property belongs to the seller and his family, and therefore the transaction was lawful. Now, Lordship, may kindly see page 34. This is the land certificate issued by the KVC. In this land certificate, as I've pointed out earlier, Teak Hill Chairman is a signatory, KVC Chairman is a signatory. One clan from Teak Hill, Zatchunyome Teak Hill President is also a signatory. And here, Lordship will find that the schedule of the land is mentioned here. Now, this document before the assistant to DC or even before the DC has never been disputed. And the legality of this document is not determined by either DC or assistant to DC. Lordship may also kindly see page 77.
Yes.
In page 77, the Teak Hill
That
clarification has been given by the Teak Hill Council. May I read, Lordship? Clarification on purpose of issuing land ownership certificate number 6 dated 6/11/2018. It is made known to us that the land ownership certificate number 6 dated 6/11/2018, which was given to Mr. Kevisena Zachu and Mr. Kelly Ukrumo, is under dispute. The certificate was issued not only to state that the land was not under any dispute and not for the purpose of supporting an argument in any case. Now, since the second portion, it says that it is not under dispute, the first portion, perhaps there is a typographical error, because in the second portion, it clearly states that it is not under any dispute. So the Teak Hill Council document and the KVC Kohima Village Council's document has never been challenged or.
But when it was under dispute, how can they say that it was not under any dispute?
This is insofar as issuing a certificate is concerned. This is only in regard to certification given to the petitioners. So these are not disputed by the respondents here. Lordship, also, when it comes to the question of limitation, since it's an immovable property, the other party is claiming that it has been become adverse since 2007. Now it's 12 years limitation. So before the period of limitation ends, the matter was filed before the GB's court. Also, the question arises whether in order to institute a case before a customary court, is there any limitation period or not? That question also arises. And also,
that is already decided.
And also, Lordship, the cause of action has been continuously arising. And therefore, and before the GBs also, this limitation has never been raised. It was only before the assistant to DC that limitation question has been raised. So this limitation, it cannot be raised at this point. And my submission is that it is within limitation period that it was filed. also the allegation that there was a collusion between the seller and the buyer, the seller and the petitioners. This is clearly unfounded. This is merely an allegation. There was no proof that they connive to act in this, to approach a forum together. And this question has never been raised at any point of time. And as far as Registration Act is concerned, yes, admittedly, my document is not registered. It is merely a sale transaction agreement.
No, not only that, it does not even indicate where the land is.
Lordship, but they were already in possession, and Lordship will find this indication of the schedule in 2018 document.
Only in 2018.
2018 document. But that has been an oversight from the petitioner and the seller, as far as non-indication of schedule is concerned. Now, even the respondent's document, sale document, Lordship, which is in page 35. The translated copy is in page 36.
Yes.
This is not a sale deed. This is
But
merely an
here
agreement.
the area is indicated, no?
Somehow
Dark
area
lane.
is indicated, but the size measurement is not indicated again. Now without the size and measurement, there may be a drainage on one side, but on the north, there is no, for example, on the north, there is no indication of measurement. And this is also not a registered document. If it is claim of the respondent that the document has to be compulsorily registered under Section 47 of Registration Act, this same document should also have been have been registered, but it is not registered. We are standing on the same footing. So, Your Lordship, there is a lot of disputed facts involved in the present case, which I'm disputing, but my submissions were not taken into account at all. Besides, the impugn order, Section 8, Para 8 clearly states that the operative part, it is just reaffirming what this Honorable Court has decided in the earlier revision petition, and the appeal was not heard on merit, and therefore I'm aggrieved because of that. And if I'm to seek a legal recourse before a civil court later, then res judicata will definitely apply, Lordship. So it is my prayer that the impugn order passed by the Deputy Commissioner may be questioned set aside. It may be either remanded back to the same court to adjudicate or on second appeal, or, as I have prayed before, it may be transferred to a regular civil court for hearing on second appeal. That's my humble submission, Lordship.
Good.
Your Lordship,
Yes.
let me put something on record. I thought I will not mention, but since my friend has leveled something against me. Now, the Civil Appeal 2 of 2019, which I have read out in paragraph 2, facts of the case, that was filed by me, and copy is enclosed with this appeal memo.
Yes.
That reply was also enclosed. By that objection filed by the present petitioner was also enclosed. Against that objection, we filed a rejoinder. That was not enclosed. That is one.
Okay.
Second one is, now in this appeal memo, the last appeal memo filed before the Deputy Commissioner, out of which the present impugn order has been assailed, has not been enclosed in this petition. That has to be on record, since certain...
Wait. What did you say? What has not been enclosed? Your
appeal memo-
rejoinder also not enclosed?
Not enclosed. Then the appeal memo filed before the Deputy Commissioner in Civil Appeal number 2 of
DC in Civil
2023
Appeal 2 of 2023.
was not enclosed. Then, now my friend is relying on the Kohima Village Council land certificate. I said this was obtained dishonestly. Because see, north, south, east, west, from where did they get this boundary? When their purchase paper did not say anything about the boundary. Where did they get this one? Is manipulation, dishonesty, fraud. This is fraud. Who gave this boundary? At page 75. North and Lao, south stream, east circular road, west stream. From where the petitioner got this? When they are only relying on the so-called sell deed or purchase deed or whatever it may be called, that paper. And as far as limitation, law of limitation and law of registration is concerned, the law is settled. That we cannot explain. Then about my agreement document. Now I can use it. I can use it not for the purpose of establishing my title, but for the purpose of establishing my possession of the land. I can use that document, and that will be admissible to prove my possession of the land. That is not a sale deed, that is not a registered document, but unregistered document can be used in relating to immovable property to prove my possession of that land, not for establishing my title. That is the law. So those laws are settled. So by explaining this, overlooking by the purchaser, those are no grounds to interfere with the impeachment, and also no grounds for a remand to any other court, and this petition is, revision is liable to be dismissed. Oblige, Your Worship.
My Lord,
Yes.
I may be permitted to.
Yes.
As far as this reply is concerned, my sincere apologies to senior counsel here. It is an oversight and I stand corrected. Yes. Yes.
It's okay. We will not go into all that. Heard learned counsel for the petitioner, Mr. T. Kezi. Also heard learned senior counsel, Mr. Ari Ralu, assisted by Miss such and such. Your name for the sole respondent.
Yes.
For the sole respondent. Matter is disposed. Chamber disposed.
Oblige, Your
Yes.
Item number 5.
May I please, Lordship?
Yes.
I'm for the petitioner, Lordship. Lordship, this is a civil revision petition, Lordship. Yes, For admission, Lordship.
Admission.
If they are ready, Your Lordship.
No, not today. Not today.
My Lord has had a full day.
Yeah, that's why. mentally, the brain also has some limited capacity.
Lordship, in addition.
Can we list it for another day? Because I think
Yes.
pleadings are all complete, na? Already.
Yes.
And,
Yes.
and what about trial court records? Trial court records have also come.
I do not know whether that report has been called for. Perhaps it has not been called for.
It has not been called for.
Not called. Will it
Not
be
called.
required? Will it be required?
For reference, it may be required. That is for the reference.
Because,
of
for
the own
example,
court, if not-
see, in the
yes.
previous case, I found that in the petition, the appeal memo before the trial court was not enclosed.
Yes.
So only from the trial court records I could see the appeal memo. So it's like that. Sometimes, you know, you miss out things in the petition file before this court. Let me just see. Okay.
In fact, the entire record is not annexed with the present petition. So if for reference if that may be required, then it may be called for Your Lordship.
Order dated 23/10, it says it is submitted by the learned counsel for the petitioners that pleadings in the matter is complete and the matter is ready for hearing.
They are actually aggrieved by the order dated 13/6/2025, where the present respondent number 1, that is my client, has been, his name has been removed as the defendant in the case by the learned court below. So in that sense, if the entire record is also called for, perhaps for reference, it may be.
It was never called. It was never called. Which court?
The learned court of the district, principal district judge, Ziniboto.
Okay. Learned counsel for the petitioner, Mr. Nikato Wotsa, is present through VC. Stop. Learned counsel, Mr. Joshua Sheki, is present for the respondent number 1. So, upon going through the orders, it is seen that the trial court records have not been called. Stop. This court finds it necessary to refer to the trial court records, and accordingly the registry is directed to call for the trial court records from the Court of District Concession Judge Zenipoto, and thereafter list the matter for hearing, okay? For hearing after 3 weeks. 3 weeks.
Lordship, if I may, Lordship, it's actually fixed. The matter is fixed for tomorrow, Lordship, in Zenipoto as well. So, Lordship, my other prayer is that an interim may be granted, Lordship. A stay may be granted during the pendency, Lordship.
It is fixed for what tomorrow? Hearing?
For inspection of documents. Yes, Lordship, for inspection of documents in Zenipoto.
Documents.
Fixed for tomorrow, Lordship.
Okay, till the next returnable date then.
Yes, Lordship, if it may be stayed.
So, proceedings of what? That will be civil suit 1.
That's civil suit 1, Lordship, 1 of 24.
Stop. Para. In the meantime, the proceedings of civil suit number 1/2024 in the Court of District and Session Judge Zeniputo shall remain suspended till the next returnable.
Lordship.
Yes.
Lordship.
Please, Lordship.
For orders, item number 13.
In that disposed matter, no? Just put this.
This is a contempt petition.
Yes.
This order was passed on 8/5/2025. Directing the respondent to consider the case of the petitioner for compassionate appointment.
For compassionate appointment?
Yes, against one of the vacancies. Because during the time of hearing, Lordship, the Mr. Respondent produced the statement, latest statement. In the statement, it has been shown that there are 24 vacancies available at the time of hearing. The Procedural Number Court, by order dated 5/8/5/2025, Lordship, may kindly see page 18 of my.
Notice complete.
Yes, Lordship. Only one respondent, condemned, no, Lordship.
And Mr. V. Zimomi has
Zimomi
entered
appeared.
appearance.
However,
Today none appears. Let's give them an opportunity. Wakalatama has been filed, but they are not appearing. So,
otherwise, order is very clear. And
But
now,
still, since they're-
considering the conduct of the respondent as well as the counsel, appearing for the respondent, Lordship.
Give them one chance.
Lordship.
One more chance. Learned counsel for the petitioner, Mr. Wati Jamir is present. Stop. Mr. Veto Zimomi V. Zimomi has entered appearance on behalf of the sole respondent and has filed his Wakalatama. However, none appears for the sole respondent when the matter is called. Stop. In order to give another opportunity to the respondent, list the matter after a week, after 1 week.
Obliged.
For orders from the supplementary cost list, item number 37.
This is the mediation list, no?
Yes.
None appears for the parties when the matter is called list after 1 week.